David and Brendan and myself are looking at week 9, the contradictions of registered designs. And we've broken this up into 3 separate parts, so we'll all be doing our own little spiel on things. I'll be having a look at what design is and why we actually want to protect it, and that it being a property asset and so forth. And then I'll be having a look at the a really quick run through on the statutory requirements in order to protect a design. Then I think Brendan is going to come in and have a look at all the common law and any defences available in equity, if there are any. And David's going to run through a working example as per the workshop that Scott set out in the notes, and just having a look at the most important aspects of that. So is everyone cool with that?
Yep.
Yeah?
Yep.
Excellent. Okay. Well, what is a design? I can't actually see when I'm looking at what I've got here, I can't actually see you guys writing. So just if you've got any questions, just give me a minute and I'll have to switch through the different screens.
Sorry, Natalie, I just logged on, but I was one of the leaders as well.
Oh, I didn't know about that. Sorry.
No, that's fine. So should I just speak like after you guys, or?
If you want. I don't mind. However you want to run with it.
Yeah, I'll just run with it. That's okay. Thank you.
Okay. Okay. So what is a design? It's really hard to define, but I did happen to actually find some definitions given by people to try and sum it all up. It's a plan for arranging elements in a way that is best to accomplish a particular purpose. I guess the end result is the design, is the end product, and it's the expression of that purpose. It's basically a process, and it consists of 5 core skills: creativity and innovation, aesthetics and quality, human factors and values, performance and technology, and completeness and presentation. In a nutshell, design can be explained as anything you come across in the world that's been altered by man. IP Australia is the Australian government agency that controls intellectual property rights and the legislation, and they define it as such: the overall appearance of a product, which includes the shape, configuration, pattern, ornamentation, which, when applied to a product, gives it a unique visual appearance. The definition provided by IP Australia also reflects the governing legislation, which can be found in Section 5 of the Design Act 2003, which provides that the definition of design in relation to a product means the overall appearance of the product resulting from one or more visual features of the product. The Act therefore goes on to say that the purposes of the Act is a product is a thing manufactured or handmade, and it says that a visual feature in relation to a product includes the shape, configuration, pattern, ornamentation, and ornamentation of the product. So the IP Australia and the actual governing legislation all try and have composed it all in one to make sure that it all makes sense. So it's basically the end product. It's the visual appearance of it in the end. Sometimes, I guess, because it is so difficult to explain it as a thing and more of a process, to kind of get a better grasp of what a design is, it can be, if we take more, if we have a look more closely at design disciplines and how they're actually categorized, we'll be able to understand it a little bit better. There is things that we already know, such as industrial design, which is looking at human factors and how a product actually is used for human consumption and human usage, consumption, and behavior. So designs for computers, phones, construction tools, kitchen equipment, splints, medical medical materials such as elbow splints, wrist splints, and vacuum cleaners. So all of these things are designed to make things easier for human usage. Architectural design is another one, digital design, software design, urban design. So, I mean, it can encompass a number of things, and it looks at preparing drawings, illustrations, models, and then the prototypes. I'll just flick back to you guys now, just in case you're speaking, which is aren't. So I'm really blessed with that. Thank you very much. Okay, so why do we protect it? Well, it gives us exclusive rights. It gives us property rights. It provides the creator of the design and gives control over the visual features of shape, configuration, pattern, and ornamentation. It bestows in the creator the exclusive rights to use and authorize others to use the design. Essentially, it vests in the owner exclusive property rights, allocating a measure of control over the use and alienation of, and to some degree, the exclusivity in the enjoyment of the design. So it's very much like the Torrens land system, whereas once you actually register, you're provided with a legal interest or a title. So to me, I could actually understand it better when considering property rights in land by already studying Torrens, and it's the same thing. So once you register it, you're vested with a legal right, which is recognised at law. So the creator basically owns it. Is there any questions there? It's very quiet. No, Margaret, I haven't.
You know, I was just thinking about that when you were saying about the like the purpose, or the value of design. And I just remembered, because my granddaughter's right into Minecraft, and I remember seeing a story about how that's used to teach young people in school, and it was around designing outdoor spaces and things like that. So I guess, there is...
Yeah, sorry, go on.
No, I just mentioned it because I just was wondering about the value of, the educational purpose of design as well.
To be honest, I didn't really have a look at that element of it. I'm just about to go in and have a bit of a chat in regarding commercial and legal assets, how it is like a legal intangible asset as well. But I didn't, to be perfectly honest, I didn't really have a look at the educational purposes of design.
Yeah, I haven't looked any more at it either, but I just thought I'd throw it out there anyway.
Okay, well, it's a different thing to look at. And Kit, David's going to talk all about that as well. So I don't want to go too much into that when I know that another colleague is actually going to run through that. It's important.
I guess the point, sorry to interrupt, but I guess the point is design is very, very broad, and even under the legislation, it's very, very broad. And that's interesting, and possibly why it's not used very much.
Yeah, it's extremely hard to define. It just encompasses so many different things that, again, that word abstract, it is quite difficult. Okay, so the next part that I did a quick research on is the protection of commercial and legal assets. So it's important that the creator possesses a monopoly or control over the design, because it may prove to be a valuable commercial asset. So in other words, the uniqueness of the design is actually what is being protected, as it may have potential to generate value or wealth for the owner. So in turn, providing a competitive advantage over those in direct competition. So innovation and uniqueness form the bedrock of competitive advantage. So protecting that through design registration ensures the owner maintains control over something that its competitors lack. It allows a creator to differentiate themselves from rivals, and most importantly, forms a resistance against those that wish to copy their design. The registration itself is a legal intangible asset, and whilst providing prevention against copying, it also provides the owner with exclusive rights to commence legal action if an infringement has been deemed to have occurred. I'll just go back to the screen now just in case you guys are talking. Nope. All right, so designs can be potentially protected by copyright and design registration. However, there can be some confusion as to which regime of protection is the most appropriate to protect the design, particularly when types of protection appear to overlap. Generally, the type of protection chosen will largely depend on the intended use of the design. Designs which have an industrial or commercial use are generally registered. Design registration protects the appearance of a product, not its function. And that's, I guess, when I was doing my research, that was actually quite important because they can both overlap, and you don't really know exactly, where to go or what you're supposed to do because, you need to provide for different aspects. You need to provide a different regime or a different type of protection. So it's hard to differentiate sometimes between what you really actually need to, the way in which you need to register something or the way in which you need to protect it. Designs which have an industrial commercial use are generally registered. The function of a product is usually protected by a patent. However, it is important to note that visual features may also be closely associated with the function of the product. Regardless, the design will still qualify for registration and the function will still qualify for patent. Sometimes you can actually you can register them in both ways. Like for the function, definitely you can, and then for the design, you can for the appearance of it. Sometimes also you can actually have the same thing registered under two different regimes, but once it applies to industrially, I haven't got it written down in front of me, but once it applies industrially to 30 different articles, particularly if it's a 3D design, then it automatically loses copyright. So all of that starts to get really, really confusing when the different elements of how a design is used and how often it is used, you start to lose different types of protection that's already vested in it. Have you got anything to add, Scott? Last week you were chatting away and you've been quiet.
Well, you're doing such a good job, so I don't want to interrupt you and put you on a tangent, which will take you completely off track. So I'm nodding.
Okay, I can't see you because I keep having to flick through, so I can't see you, but I'm glad I'm on the right track. Copyright design will still qualify for registration, and the functions will still qualify for patent, as I just said. Copyright protection merely provides against someone copying the work. Now, this is extremely important. The onus is on the copyright owner to prove that copying has occurred, and unlike registered protection, copyright does not afford the owner protection against another design independently arriving at the same independently arriving at the same work. So it protects design registration will protect innovation, whereas copyright won't. So that's what I thought was actually really important. Now, it really confuses me, but the complexity of deciding which regime is most appropriate when it comes to fashion design is absolutely beyond me. I have read, Scott, but it is that confusing. I understand that you can't, like with a certain type of stitch or a certain type of like a pocket or a sock, you can't, because you can't stop people from making general things that for everyday use. However, if it's something like a ruffle skirt or, for instance, Speedos, apparently they're different and they can be registered. So
Speedos are probably a trademark. It's probably how they go.
Well, I thought that too, but when you have a look at IP on the IP Australia, it goes in and gives you a case study, and it gives you a table of all the different types of fashion design and different, like the ruffles, and the type of material that is used wasn't under trademark. It could actually be done under design registration But and then there's a table of all these different types of stitches and types of elements of clothes that can and cannot be. It was very, very confusing.
Yeah, and
Whoever's just talking in the background there, not you, Scott, but I can't hear you. There was another female voice. It's really like you're in a tunnel.
Sorry, can you hear me now?
Kind of. I'll do my best.
Can everyone hear me clearly?
Yes, I can.
Great, thanks. Do you mind if I just speak on the fashion design part of that?
Yeah, if you've got something I don't, by all means, please jump in.
I've just got something small, but hi guys, I'm Polly and I'm like one of your workshop speakers, and I did a bit of research on the fashion designs and stuff, and what I kind of gathered was that the fashion labels and stuff would register their most unique design. So what they would actually be registering would be like the prints of the actual styles, like just exclusive prints, materials, just pretty much prints that could deter people from copying, like probably their most unique pieces. That's what they would that's pretty much what they would just register.
Can I ask a question? Why is the fashion industry, I guess, in terms of IP and registering designs, why does it have such a low IP protection? Does anyone have any ideas about that? Has anyone watched the video, for example, where they talk about that a bit? Why is fashion different to, say, let's say, movies or music? Any idea? No?
No, sorry.
Well, I guess. Yep. Go, Margaret.
No, I said no. I don't have any idea at this point. Sorry.
traditionally,
Okay.
there's a gendered part of it too. A lot of the old copyright cases say, yeah, of course, a work of literature or of science is important to protect, but a piece of clothing, that's of no importance to society, because the people who make clothing don't create art. So you've got to remember that a lot of this law was written quite a while ago, and there certainly is a prejudice against things like recipes, clothing, whatever, that were perceived for a long while to be part of things that were done in the home, not things that were done by professionals. And there is a definite gender aspect to it.
That's
Yeah,
right.
I have to agree with Scott. I just think it's only starting to be the bigger companies and brands like Finders Keepers and stuff that are starting to actually register their collections. But besides that, it hasn't gone as big as what it kind of. I guess it's
Well,
just.
I guess they also borrow off each other now as well, which increases their market share. I mean, if you look at companies like H&M and, I mean, now they're teaming up with these high-end fashion designers to target a different area of the market. So I guess in fashion, it increases their market share, which would be another reason for having such a low IP protection. I guess there's more players, I guess, in the fashion industry than probably with film and music, etc. That'd be another reason. Sorry if I can't. So, sorry, Natalie, do you want to finish or? Sorry.
Yeah, righto. I'll just finish off on this legislation. I've only had a look at the governing laws and its application regarding statute, so I'm pretty sure that most of you have had a look at it. It's design registration is governed by the Design Act 2003 Commonwealth. Sorry. Did someone just speak then? No? All right. where was I up to now? Sections 15, 16 and 19 stipulate the features a design must exhibit before it can be registered under the Act. A design will be registrable if it is new and distinctive when compared with the prior art base for the design as it existed before the priority date of the design. So the prior art base refers to designs publicly used in Australia, designs published in a document within or outside of Australia, and designs which have previously been disclosed in a design application. For a particular design to be recognised as new and distinctive, it must not be identical or be substantially similar in overall impression to a design previously published in Australia or published in a document anywhere before the application to register the particular design was filed or a design previously disclosed in an earlier registered design application. It kind of goes on like this for a little bit. There is tests that people that I guess the people that are looking at it to decide whether it is actually similar that they have to follow. I'm just worried about running out of time. So, Scott, do you want me to continue to talk about the legislation? Because I know that we want to work through some other things, but basically, it's governed under the Design Act. It's a federal act. It's not a state act. And there is particular elements that have to be met or they have to be satisfied in order for it to be deemed similar, to be not deemed similar, and the creator is then afforded with the legal rights. So,
yeah, we could look at specifics if we need to, but I think the legislation is quite straightforward. The thing that's complex is its concepts that it doesn't define really well.
No, and it is. I've broken it down in this report, but it is really hard to talk about it and then to express it verbally. It is easy when you're reading it. It kind of follows through. This equals this equals this, and yeah, there is recourse. There is recourse in the event that someone's right has been infringed. But I do know that Brendan's going to talk about that as well. So. If you guys do want to have a look at it or are interested in the steps or the elements that need to be satisfied, then just jump on and have a look at the Designs Act 2003. It is pretty straightforward. That's about me.
Cool. Who's up next?
I might go with the registration process. I put a document on Moodle earlier, just basically outlining steps to register a design. So obviously the first thing to do is to have a design in mind, and then start searching the databases. The first one to look at would be the IP Australia's database, and that's the Australian Data Design Searching. I don't know if anyone had a look at that, but it was a little bit difficult to navigate and just to find anything usable or just, it was a little bit strange. But anyway, I found one site. Sorry?
I said it was really difficult.
Yeah. It's,
even when you use generic words, it was just it's really hard to navigate.
I found once that I had my Locarno classification, for my design, that made it, obviously that was a lot more specific and made it a bit easier, but still there wasn't a wide variety of designs in there anyway. So, but anyway, yeah, so you'd start off by searching the database to see if there's any similar designs out there. And then the next step would be, check the classification of it. So the Locarno classification is a classification for industrial designs. They comprise of a list of 32 classes and 219 subclasses of industrial designs, and they're used in over 7,000 different kinds of goods. I was absolutely amazed by the scope of what was in there, and just huge amount of stuff. Does anyone else have a look at all at on the Locarno site at all?
Yeah, I did. Yeah.
Yeah, I searched the design on there.
Did you find it easy to navigate?
It was actually quite hard.
I found it hard. I found it sometimes you'd click on a link and it would go into Spanish or French or something.
Yeah, it's a whole different language.
Yeah, so that was a bit frustrating. So my design anyway, I'll put it, I don't know if you guys can see that very well, but if you can see it all right. It's basically a design for a guitar body. So my design class is 17, which is musical instruments, subclass 03, which is stringed instruments, and there was a serial number as well. I'm not sure why that was for, but it was G0224, and that was for guitars. So that's kind of the first process in making sure that you have a design and a classification for that design to start your searching. The next thing, I guess, is really the new and distinctive test. Is your design new and distinctive? And we were just talking about the Designs Act before, but Section 15, subsection 1, sets out that the basic legal criteria for a grant of design is a registrable design if the design is new and distinctive when compared to the prior art base for the design as it existed before the priority date. So you've really got to then have a look at what's out there and just see how yours compares. So I've got just a bit of a case that I found which interests me anyway. It's about the Fender Musical Instrument Corporation in America. And so basically they're a big company who produce musical instruments, guitars mainly. And what the case is about is that it's in the United States Patent and Trademark Office, and it's from 2008, so it's a little bit older. But basically Fender wanted to go ahead and register the designs for some of their guitar bodies. So they'd have a trademark. Fender is a trademark, so they wanted to actually register the design of the body shape. Now, there was a lot of opposers to that, and I think there's probably close to 12 or 13, and these are other smaller guitar manufacturing companies. And basically, they opposed Fender's application to register the bodies on the basis that because the body shape and the guitars have been in the public domain and around for such a long time, like 30 years or more, that they were just generic and that they didn't meet the new and distinctive test to gain protection. So they ended up winning that against Fender, so that Fender weren't allowed to register the body shape because, I guess it kind of comes back to that whole fashion industry thing again too. Like, something's been out there for such a long time and it's generic, and you can obviously trademark your brand, but a body shape or a sleeve cut or something like that is really hard to register that actual design shape. So it was interesting. I'll post the actual case on the Moodle site after this so people can have a read if they want. I found it interesting. You may not, but anyway, the next thing is to apply for the design. I posted the paperwork as well for that on Moodle. So it's basically there's an application form and also a new and distinctive application form as well. So they're all out there, and all this information is all on that IP Australia website, which is really useful and a really handy page to get a lot of information of. When you're applying, you've got to provide a representation, so that's obviously an illustration of your design, and you've got to highlight the new and distinctive features of the design. There is a statement of newness and distinctiveness which is optional to provide. I wasn't sure why that was optional. I don't know if anyone has any idea on that. No? Okay. All right. Also, the statement can't be added after registration, so you can kind of get one shot at it, really, it seems to be. There's a fee payable, And I think basically because you can do it all online, that'd be the way to go. And it seems to be about $250 online, and it's $350 if you try and do it by mail. After that, there's the registration, which they do a formalities check, and that's an actual examination of the design. And then after that, I guess if it progresses through, you can request registration. And if you don't immediately do that, you've got to do it within 6 months of filing your application if you want it to be registered. Once it's registered, it'll be searchable through the database, so that your design will be on the database for people to see. And my last point is that publication is an alternative to registration. You can request publication when a design is unable to be registered. It might already be in the public domain, and it may not meet the new and distinctive test. And that's about it from me. Any questions, any thoughts, comments?
The optional statement is bugging me. I must admit I saw that and then sort of forgot about it, because one of the central principles of being a lawyer is telling people never give more information than necessary. So yeah. It does seem unusual to say, well, you can say it, but, you know, if you don't say it now, you can't say it later. Yeah. But a lot of this stuff is legacy from an old pre-internet era too, when things would actually be filed. And I believe the computer system the design database is running on is probably a pre-internet database too, probably pre-Windows database. So that's why it looks so weird.
Cool.
Scott, is it okay if I just briefly go over everything now as the last workshop leader?
I think Brendan was up next.
Yeah, Brendan needs to speak.
Sorry.
Oh, sorry, Brendan. Sorry.
That's all right. I'm just going to talk a bit about the benefits and consequences of non-registration, I guess, and maybe look at a bit of the law regarding the remedies as well. I was just wondering if anyone knows what would a benefit be of registration of a design. Why would we do this or not do it, I guess? Any ideas?
Pretty much forces your rights and stops people from copying.
Yeah, that's right. And I guess it gives the owner exclusive rights to make a product, import it, sell it, etc. So, yeah, that would be some of the rights.
You may find it's also, sorry. You may find it's also like a foundation right that you don't actually use in yourself, but a lot of other rights stem from it. So if you are going to be involved in marketing or whatever, you by getting the rights to or getting permission from the person who has the registration rights, that could be part of the goodwill of your business and all those sort of things as well.
Right. Yeah. And as Scott said, I guess it also it's personal property that can grow in value and can be sold over time as well between other people. I mean, if you take a look at the example of the fashion industry, which was, I guess, the topic of the video and the reading, I guess as an alternative to registration, with the example of the fashion industry, a benefit would be that it has a faster establishment of global trends, which is what the fashion industry is all about. And you have this idea of this physically fixed expression versus an idea concept, yeah? So property could be seen as art versus something that's free, which is, you know, the utilitarian argument, the utility argument of something. For example, and the digital age, I guess, has changed this a lot, because these days we don't recognize things like music as a physical item any longer. We can transfer it digitally between each other. So I guess these are the alternatives to registrating it. And if you don't registrate it, then, for example, like the fashion industry, it can increase your market, and you can take parts of designs and change it and use it to create something new. So I think that's a good example of the benefits of non-registration. Again, it would depend on your industry and your customer base as well. With fashion, I guess there's a lot of players in the market, so it's not such a limited market when you compare it to something like music or film. Yeah, there aren't that many players in the market, so maybe the benefits of having a low IP protection there aren't as many benefits in those type of industries as there are in the fashion industry. I mean, they thrive off this idea of people taking designs and changing them and manipulating them into something new. So, yeah. In terms of the remedies, I guess looking at the law, the remedies, I guess a court may grant infringement proceedings, which can include an injunction, or at the option of the plaintiff, damages on account for profits. Also, the court may refuse to award damages, reduce the damages that would otherwise be awarded, or refuse to make an order on account for profits if the defendant satisfies the court of a number of things. For example, at the time of the infringement, the defendant was not aware that design was registered. Yeah, so there's some of the remedies, I guess, legal remedies that you could undertake if your design was used without your permission. I guess some of the other things as well that I looked at, you also have this idea of the piracy paradox, whereas in the fashion industry, copying, at least in that industry, may actually promote innovation and benefit the originators. It benefits the designers by inducing a rapid turnover and additional sales. I mean, fashion is cyclical; it changes all the time. So there wouldn't be much purpose in registering designs because it's moving so quickly, and it obviously costs money to go through this process of registration. So there's not much point in doing it. I guess in the fashion industry too, they also have trademarks which protect particular brands that can be quite valuable. I guess the trademark of them, how they look. Yeah. What else was I going to talk about? So, I guess those are some of the benefits of non-registration, and the example I guess I mainly looked at was the fashion industry. However, there's also the idea of confidentiality and secrecy. For example, I guess a recipe, once it's registered, other companies can see what the recipe is and manipulate that. So that would be another alternative to registration. And I guess examples would be in the fast food industry, you've got KFC with their 11 herbs and spices. So in some instances, there really is no benefit in registration of the design, because it might open you up to, people trying to copy you, taking parts of your design and using it for their own purpose. So really, I think it comes back to a question of, what's your industry, what's your customer base, whether or not you are going to go, or whether or not it's worth to go through the process of registration of a design. So, I mean, is it possible to borrow parts of a design from other sources to create a new design? Do you think that's possible under law?
In the last week, we're going to look at some of the open futures that are being suggested. And one of the things that the argument you're making is part of a bigger evolving argument that sometimes copyright gets in the way of innovation. And I don't remember if it was patent. It might have been a patent or a trademark. In the 90s, Marvel Studios tried to restrict the word superhero and stop anyone else using it. And it's a very interesting example of when you look at the two big players in the field, how they've gone in quite different directions, and they actually feed off each other and actually create more innovation than one would necessarily by themselves. So, yeah, DC don't necessarily want everyone making Superman movies. But if taken too far, you can actually lose a lot of market synergies by stopping people actually engaging in that way. So it's a theme we'll return to in the last week.
Okay, cool. So does anyone have any other questions? I don't think there's anything else I wanted to cover. Maybe, Pauline, do you want to take over?
Yeah, sure.
Bye.
Cool. Thank you, guys. I won't take up too much of your time. Everyone pretty much covered everything. Natalie covered the legal and legislation part. David covered what I pretty much wanted to cover, the registration part. I'll only speak on a little bit of what we missed, which was the part on International Convention for Protection of Industrial Property. So that's another thing to consider when trying to register designs and stuff. That's the last part you can consider. So you can apply for a design in a foreign country by following one of the two strategies. You can make a new application in each foreign country as if you're making an application for your design for the first time. That's called a national application. Or you can make a new application in each foreign country within 6 months of your Australian application and specify that you are claiming the date on which you lodged your Australian application as the priority date of your application. That's called a convention application. It has a few advantages when applying for the convention application. You have up to 6 months to lodge an application in a foreign country. The date of filing of your Australian application is the priority date. Any public disclosure of your Australian application during those 6 months will not affect the newness of your foreign application. And pretty much how to make that application, you would just make it on the foreign country in the same way as we do it on the Australian design page. In addition, you may need to supply just a certified copy of your original Australian application. That's pretty much all I saw that we missed on the registration process. So in conclusion, a registered design gives you the owner exclusive rights to commercially use, license or sell it. Once you register your design, you have protection for 5 years from the date of your design, and then once that's finished, you can file to renew it for another 5 years. In regards to registering the design in the fashion industry or any industry in general, you can register. If I was giving advice to a client, I would pretty much just say register your most unique designs or exclusive prints. When making designs distinctive, you could look at the handwritings or the uniqueness of the designs and the patterns that you use. Registration pretty much deters people from copying and making more out of what you designed. I'm pretty sure we covered everything. Does anyone have anything to say?
I just wanted to also say that in the instance that there has been an infringement, the actual infringer can apply to the to IP Australia and actually with a counterclaim, and they can seek to revoke a registered design that has and they can actually ask that it be reviewed again on the basis that it's not new and distinctive. And if it is re-examined, they can actually have it struck off the prior art base, and then the actual registered owner loses his legal interest in that property as well. So I just wanted to, just to say that they can actually counterclaim that in the instance that there is an alleged infringement. And that's it. That's all I got.
It's interesting, isn't it? The sheer complexity of, and I guess this is why amateurs definitely don't go into the registration business, and even firms. The cost of having someone to actually register and then looking at international markets and then trying to make sure things are registered correctly across international markets, it's pretty daunting. And I don't know that the remedies are necessarily all that effective, depending on what particular line of business you're in. So one of the things I find interesting about registered designs is on paper they seem to work really well. On paper they seem to say, yeah, let's take the protection that's offered towards copyright protection and let's form a version of that for things that aren't covered by copyright. But in practice, it doesn't seem to quite work. And I think that from a legal policymaker point of view is kind of interesting as to why doesn't it quite work. Any takers? Well, we know about the growth of copyright. Okay, copyright is something that used to be only applied in the minority of cases. In fact, once upon a time, it used to have to register things with the copyright agency to get copyright protection. And now everyone knows about copyright to some extent, even people who are breaching the law all the time. They know something. They might not know the right thing, but they know something. Registered designs have kind of languished, and from let's talking about design. If you think of the law as a design, I mean, the law is actually something that fits that definition of industrial design. It's an artifact created to help human beings function in a certain way. Now, we also, I thought that the TED Talk this week was interesting as well, talking about, well, why fashion doesn't bother. Now, how do we fix registered designs to make them work better? Okay, that's the question. If the problem is it's not being used, how do we fix it?
It's nearly impossible to find anything on the art base. So even if you use generic words or not, it depends on. It's like when you put in, like in Seek, if anyone's had to actually post an advertisement on Seek, it's the generic words that you use that if somebody else is going to use or associates those words with the type of product that you want, they can put that in. But if they associate that product with another key word, then you're never going to find it. So what is the point of having an art base when you can't find anything? It could be there, but it could be under something completely different.
Yep, that's a good point.
Scott, just going back to sort of what you were saying in terms of the effectiveness and how it can be more effective, is it, and this is going to sound very pessimistic, but isn't it a little bit of a moot point in the sense that you're talking about consumer behaviour? The times, when you look at consumers today compared to 50 years ago, 100 years ago, the sort of the consumer who's looking for the stable, the trusted. Most consumers want the latest iPhone. They want the latest handbag, or whatever it is, the latest computer, the latest upgrade. Sort of, when you look at the culture of technology and advancements and how the market has changed, consumers have become market-driven, and consumers are looking for the latest, greatest thing, and it doesn't matter what it is. So it seems to be sort of, when you look at the fashion industry and the way that they try to promote themselves with a specific product, it doesn't matter if someone comes and copies it, because this is our brand. It's going to be good. You can run around saying this is what it is. Isn't that sort of a bit like whether it's a computer brand, Apple, IBM, Asus or Asus, depending on how you want to say it, but isn't that the same? And doesn't that sort of make it a little bit pointless?
Yeah, I think you got a point. And there's also that weird thing around knockoff markets. Like an Eames chair, for instance, would be something which would be a registered design, and it's a timeless classic. But an original Eames chair is a very expensive antique now. There are places who do knockoff versions of the designs, but you're buying a knockoff. And the same when you're buying like a not quite right iPad. It's kind of a different market. So I think the ideas underpinning the design's registration, as Grant suggested, haven't really, it's part of an old world way of thinking. It's also part of a way of thinking where the illicit markets for knockoff goods were not so visible. I mean, I remember, I'm just going to sound like an old man now, but I remember back in the day when Singapore had no IP protection, part of the thing of doing a trip to Singapore was you'd come back with all these knockoff fashions and DVDs and whatever. Today, it's, you go to China for a similar sort of experience. But those were things people went on an overseas trip to get. It was quite difficult. You couldn't just get online and order a knockoff Prada handbag. You had to go looking for it. So yeah, I think the market is a very interesting point, and I'm hogging the conversation here. I mean, I don't know if you guys think I'm slightly mad by putting in an area of law that doesn't quite work into your study. But at the back of my mind, no matter what you're studying in law, what you're working on is your skills as a legal designer, as a legal rule maker. And I think part of what we do is not just learning what the law actually is, but trying to develop a critical idea of, well, how does it work? Because I know in the public discourse, what do people say is the most effective way of fixing a law that's not working? Look at the conservative newspapers. If there's behaviour that's not being regulated, what do you do?
Change it, I guess. Yeah.
Yeah, but how do you change it? What's the knee-jerk reaction people have to if there's a law that's not being complied with? Harsher penalties.
That's right. Crackdown.
Crackdown, more power. But one of the ironies of legal control, and if you study any criminology, which unfortunately don't get a chance to really do in our degree structure, but I think it's quite useful, even if you don't never practice in crime. But criminology is quite interesting because there's a whole lot of study of deterrence as a thing. And there's all these ironies of deterrence and the harsher penalties you apply. Sometimes you actually increase crime. for various reasons, for things like, you decrease your success of prosecution. This is one of the problems of the death penalty. Apart from any of the moral concerns people may have around the death penalty, you simply don't get very many convictions comparatively where you have a death penalty. And when you do get convictions, they tend to be along racially biased lines from the US data. I mean, not necessarily the same experience here. So, yeah, I think where you have an area of law that's not working, people are saying what we need is higher penalties. And this has happened with copyright law, and this happens with, as Kit said, incentive or stick. Law's not very good at incentives. You can't really think of very many areas of law where the law goes, well done, here's a nice reward. Most of our tools are sticks. However, I suppose maybe IP is a kind of a reward because we say, here you go, you get to commercialise something you've created. Theoretically. But one of the things I'm working towards in the big picture in this course, hopefully, is this idea that we're now looking at broader options. And next week, this is a segue. Next week, we're going to look at some of the problems we've got ourselves into with an increasingly harsh, increasingly locked down view of IP and what it's doing in terms of market and what it's doing by basically creating a black market. It's creating, even creating grey markets in second-hand sales and things. We're not achieving the things that we thought we were going to do with the law. The last week, we're going to look at what maybe liberalising the law and opening the law a bit more may actually be beneficial. And actually having open and shared resources may get to the point that actually drives innovation and actually drives further production.
It's interesting when you look at the industries and how much money they rake in. And what are the top three? The top three are fashion, food, and automobile industries, and they all basically have a low IP protection. And then you look at film, music, the other industries, and the amount of money they make is so much less, but they have this idea of protection.
There's a really weird situation with video games at the moment that the market was booming for so long, and there were all these projections saying video games dominate the entertainment industry, they occupy so much. But what we've found is that the money is being made by second-hand sellers. So all the money that's in the game industry, in Australia, is being made by EB Games and JB Hi-Fi selling second-hand goods, which is not actually going back as an incentive to the creators, because these second-hand goods are being sold and resold and resold. And a more severe kind of lockdown approach, which some of the game developers have tried, by having games that lock you out and you can't resell them and so on and so forth, hasn't worked. It hasn't been successful. So very interesting times, and I think it's interesting that some of the solutions that come into the problems, such as Creative Commons, are actually being created by lawyers, and lawyers are actually solving the problems that law's created. Which doesn't happen in many areas of law, really. Okay, well, we're running out of time. Does anyone have any last comments? I do need to push you guys, and I didn't do it this week, I need to push you guys more on your research assignment. We need to have a bit more action happening on DIGO in terms of defining the problem, scoping it out. Remember that your participation in DIGO is part of the accessible rubric for the assignment. It's not just a case of going away overnight and burning the midnight oil and putting an assignment together. It's actually about engaging in the research community. I'll focus more on putting some ideas into the DIGO groups. I don't know if you've seen it, I've put a video up on designing a thesis and writing a thesis. A few people have said that our program doesn't really go into some of those basic skills. And I agree, and I'm, working on fixing that. But in the meantime, there's just sort of a 10-minute piece to give you some ideas of thinking about what a thesis is. And fundamentally, this is the difference between getting a credit and getting a high distinction generally. And it's, tips for taking your work further. If you find, you're just not getting where you think you want to with your assessment, hopefully it'll give you some ideas and some tips on taking it that stage further. All right. If there are no further questions, we're not talking anyone. No, can we email your drafts? This is what Digo is for. Digo is not for drafts, and honestly, I'm not a proofreader, so I'm not going to be able to help with a draft. But what you can do is first of all start with posting. yeah. Okay, you said that the question rather than Hoff is excellent, but do it in the Digo space, because that's where you can say, hey, I'm thinking about writing about this, and other people can contribute and talk about it. And it also means that people can push resources your way and can suggest things to you, and they can be on a lookout, because they might be researching something completely different, and they go, hey, I remember Kit's doing a topic on this, maybe she'll be interested in that as well. So I'm really, really serious about the collaborative part of the research process. This isn't a situation where I'm waiting for the one person, has the really brilliant idea that they hide from everyone else, and they're going to get the high distinction because they've worked on this thing in secret. We're moving into a collaborative world. And sharing, and this is part of the thesis of IP, really, isn't it? Sharing makes everyone stronger, and helps everyone out. And I will be active getting in there and providing suggestions and things as well. So in Digo, you can just post a comment rather than posting a source, and that's an excellent way to try and get people to help. And further define your topics too. So, yes, I know it's culture shock. I know it's quite different to what you've done before, which is very much, I'm putting my hands over my work so no one can copy what I've done. But honestly, having worked in different environments, this is what this brings everyone forward, and it doesn't do any harm to the people who are already in the lead, because they actually learn a lot from helping other people. I know that sounds sappy, but it's true that by actually thinking through problems other people are having, it actually gives you a whole lot of reflection on what you're doing yourself. Because you can look at things that people are doing and go, hey, that's a problem, but I do that as well. So, let's get into it over the next couple of weeks. Alrighty.